Good morning, and thank you for joining me on the Path to Liberty. It's Wednesday, July 22nd, 2020. On this episode, I'm answering or trying to, or at least asking a big question. Can states and their political subdivisions, like localities, local law enforcement, cities, counties, and the like, can they arrest federal agents? With what's been going on in Portland and elsewhere, primarily Portland, I've been seeing a ton of rank and file left-wing people like liberals, Democrats, and the like, literally saying that law enforcement in Portland or elsewhere should be arresting feds for kidnapping. Now, that's not something that you normally hear from the left. It's actually something that's been demanded from the right. We've gotten a lot of demands from the right to do this over the years. And we've actually seen just this week and in the last couple of days, a big city DEA said he would be willing to file kidnapping charges against federal agents in his city. So I'm going to go through the logistics of how that would play out in practice under the legal status quo, under the statutes and laws on the books today. I'll explain why for years I've actually recommended, even after supporting this about a decade or so ago, why I have actually recommended strategically not trying this at this point. But there's a really huge caveat to that recommendation, and I'm going to explain that as well. And hopefully we can all make our own yes or no answer to this question in the long run. But first of all, before getting to that, my name is Michael Bolden. We broadcast live every Monday, Wednesday, and Friday at 9:30 a.m. Pacific time from here in my home office and studio in downtown Los Angeles for the 10th Amendment Center. We're on a bunch of different platforms. We're live streaming on video through YouTube, Facebook, DLive, Periscope, and Twitch. We have archive video versions at library.tv, BitChute, BitTube, and Brighteon. We also have audio-only podcast editions on iTunes. Thank you, everyone who's been leaving reviews. That really helps us out on the podcast edition. Reviews over on iTunes. Thank you very much. We've got all 5 stars, 1 4 star so far, so that's pretty awesome to me. iTunes, Spotify, Stitcher, Podbean, Google Play, and elsewhere. You can find on our show homepage. It's 10thamendmentcenter.com/path-to-liberty, all spelled out. 10thamendmentcenter.com/path-to-liberty. You can find all of the different platforms we're on. You can find all the individual archives that we've done of the show for the last 2+ years. And in each individual post for each episode, I put tons of links. Sometimes there's like 3 or 4, sometimes there's 15 or 20, because in each episode, I'm really just scratching the surface and going through highlights of reports to make a case for something. And I'm encouraging you to actually go to those show pages and click through and read all the stuff that I've read through so you can learn far more and understand the complete context. You can find all that, plus ways to follow us like our email newsletter, our social media platforms, and you can even support us through our membership program. And there are so many people who've been joining us lately. I cannot thank you enough for putting your financial faith behind our work. It starts out as little as $2 a month. Again, that's all over at 10thamendmentcenter.com/path-to-liberty. Again, 10thamendmentcenter.com/path-to-liberty. I want to say a quick hello to everyone out in the live chat. I love the live stream concept of this, and I know most people actually watch or listen to the archive, but I'm so grateful to everyone who joins me at 9:30 a.m. Pacific time, Monday, Wednesday, Friday. Hi to Funky Euphemism. Good to see you. Tyler B., Tim Martin. Pretty awesome to see you guys. Tyler says, to answer the question, yes, will they? Absolutely not. You already probably are ahead of the game on this, not to spill the beans too much. Benjamin Blonde and Andrew Nappy, my old friend down in Florida. South Coastal Salt calls me a hippie. Love from Texas. That's awesome. Gary Townsend, Bob Landry down in San Antonio, Greg McCauley. Yes, there is not absolute immunity. That's an important point about immunity, and I'm going to talk about immunity in a little bit based on how the courts apply this. Cole Cochran, Joshua, makes an excellent point. Federal laws are only supreme pursuant to the Constitution. Now, again, one of the things that I'm going to be talking about is how this plays out in practice today. And there's some important things that go on there. And then the caveat, of course, I think Joshua's ahead of the game as well there too, because federal acts are only supreme when in pursuant of the delegated powers of the Constitution. Pro-life and pro-liberty. Alan Drone, man, I'm so thankful for all your feedback and some of the quotes. I haven't gotten back to you. I saw a couple of replies from you. Thank you for the input on this stuff recently, too. Dan Reed, From the Culinary Libertarian Podcast, thanks for being here, Dan. Carlson Raider, Dennis Marburger up in Michigan, and everyone else. I apologize if I miss anybody, but I'm very grateful for you being here. I want to dive right into this. I will look through the comments, hopefully, depending on how long I ramble on this, but maybe at the end of the show and try to answer some questions, because this is some pretty deep stuff that we're getting into. Let's first start out with what I saw in a report. I actually saw a tweet and a Medium post from the DA of Philadelphia. And here's an article from Philly Voice. As Trump threatens to send federal agents to Philly, Kenney says city will resist. And here from the mayor, while the city of Philadelphia has not received any formal notification that federal agents will be sent there, we will use all available means to resist such a wrong-headed effort and abuse of power. Mind you, most of the time when a city or a state or an organization says all available means, they almost always really mean we're going to file a lawsuit in federal court in the hopes that the federal court will tell the other part of the federal government to stop doing the stuff that the federal government always does. So I would take that part with a grain of salt. But here from District Attorney Larry Krasner, and my highlight has changed, but he says this way: anyone, including federal law enforcement, he's being very specific here, anyone, including federal law enforcement, who unlawfully assaults and kidnaps people will face criminal charges from my office. At trial, they will face a Philadelphia jury. That's a pretty huge statement. It might be political posturing most of the time. My longtime blogger here and friend TJ Martinell was saying to me this morning, I think this is just bluster from these guys, and he's probably correct. But this is certainly a ramping up of that bluster on a state or a local level. This is very local here. The DA says, I will file charges against federal agents, federal law enforcement. That's very unusual. You don't hear that come up from anyone in government too often. From time to time you do, and I'm going to point out a few things. Now, that's not the first time it's happened from the left. The left generally doesn't use this type of rhetoric. It's relatively new. I actually, in some efforts against NDAA, indefinite detention, years ago, we had a lot of focus on that. I wish we spent more time on it today because it's still on the books. From the 2012 National Defense Authorization Act, they signed into law the ability to indefinitely detain people. I mean, the idea of indefinite detention is totally opposite of what the Constitution authorizes. There is no authority for it. So we worked on a state and even a local level to introduce laws and resolutions and ordinances to actually ban assistance to that practice. And I was working with a local ACLU chapter, and the coalitions we do are big. We work with a lot of people all the time who don't agree with us ideologically. In fact, almost everyone does not agree. If you're a tenther and you support the Constitution every issue, every time, no exceptions, no excuses, you'll always find yourself at odds with people on the right. You'll always find yourself at odds with people on the left. And sometimes you find common ground. And what we do in our activism is when we find that common ground, we set aside those differences and we work to get something done. And in this one, we were working with a lot of people from the left to oppose indefinite detention, even though it was signed by the previous president, Obama, and for whatever reason, the right still seemed to like this stuff or not really care. But in some areas, the hard right was really with us as well. So you saw some interesting coalitions between Oath Keepers and all the way to ACLU and sometimes even further left. But at one point, I was telling a local chapter of ACLU, I'm like, well, we're working on trying to just ban assistance in a city to federal kidnapping powers, to federal indefinite detention. I'm not saying that NDAA is anything like what was going on in Portland, but just to give you an example of the rarity of this type of thing. And the head or the legal advisor for that chapter literally said to me to my face in a meeting, said, what we really need to do is we really should have our city file criminal kidnapping charges against federal agents and arrest any federal agents who tries to do this indefinite detention. And I'm like, whoa, okay. I mean, that's pretty awesome because you're correct. I'm on board philosophically, but your national office has specifically told me you can't do this. They don't support that type of thing. And I had that conversation with New York, their main office, many times, or at least a handful of times. And the local people said, well, we're an independent affiliate, so they can go to hell. We're going to do what we want to do. But that was very rare. That was the first time I ever heard a left organization actually say we should arrest feds. They didn't go that route because the rest of the coalition wasn't interested, but I thought that was very surprising. It's relatively unusual. Now, here in California last fall, Governor Newsom actually signed a bill into law, AB 668, that, quote, provides that a person shall not be subject to civil arrest in a courthouse while attending a court proceeding or having legal business in the courthouse. And it empowers the judicial officer of the court, of the state courts, to, quote, prohibit activities that threaten access to state courthouses. In other words, it doesn't say it explicitly like that Philadelphia DA or the idea from that local ACLU chapter. It doesn't say specifically we're going to arrest federal agents, but it sets the framework to say, well, federal immigration authorities aren't allowed to arrest people in state courthouses, and we have a judicial officer that will physically prevent them from doing that. I haven't really followed up on this to see how it's played out. I'm sure a lot of you guys who follow the immigration issue far more than I do would have more insight into that. But I do think it's very interesting. And in this report that I put out about this last year, I really questioned, like, oh, are they really doing this? I think they were really kind of just setting the stage for a court case, a federal court case, that is, to try to hold their ground. But I don't really know that California ever followed through. This is an example of what TJ was telling me. A lot of times this stuff is really just talk, or its framework for federal lawsuits. Now, again, like I said, this generally doesn't come from the left. And in more recent years, it has mostly come from the right. For example, we can go to Kansas back in 2013, something we worked on quite a bit for quite a while. A lot of our supporters were on board with this. My friend Rob Wood was really leading the charge on this in Kansas to get Senate Bill 102, which was originally HB 2199 that year, the Kansas Second Amendment Protection Act, passed and signed into law. There was a lot of opposition from the right, and there's not a lot of left in Kansas, so a lot of the opposition really came from, I guess you would call what you would think on the right to keep and bear arms friendly fire, but it's really not friendly fire. And this was what was signed into law. Any act, law, treaty, order, rule, or regulation of the government of the United States which violates the Second Amendment to the Constitution of the United States is null, void, and unenforceable in the state of Kansas. Now, that's a very powerful statement, and in practice, that would really require Kansas law enforcement to stop participating in the enforcement of those federal acts. Unfortunately, that's not how they did it. It didn't play out like that, but they actually had a piece of that legislation that specifically said that they would file criminal charges against federal agents. It says it is unlawful for any official, agent, or employee of the government of the United States. This is in law in Kansas. It went to court, and it was thrown out. This wasn't actually even addressed by the court, but it is unlawful for any official, agent, or employee of the government of the United States or employee of a corporation providing services to the government of the United States to enforce or attempt to enforce any act, law, treaty, order, rule, or regulation of the government of the United States upon a firearm accessory, or ammunition that is manufactured commercially or privately and owned in the state of Kansas and that remains within the borders of Kansas. Violation of this section is a severity level 10 non-person felony. I'm not sure. It's probably a low-level felony, but they're basically saying it would be felony charges for a federal agent to come into Kansas and for a very narrow area, say that under intrastate commerce, this is a commerce clause pushback as much as it is protecting the right to keep and bear arms, the Second Amendment, and whatever that is in the Kansas state constitution. This is saying if the feds come in, we're going to charge you with a felony. Now, they didn't say they were going to go and arrest them. There was a lot of opposition to actually trying to get local law enforcement to try to arrest feds on gun control. It says any criminal prosecution for a violation of this section shall be commenced by a service of complaint and summons. So they were just going to basically file a notice, a complaint, and a summons saying that this person is under investigation or being charged. Such official, agent, or employee, this is again to the law, shall not be arrested or otherwise detained prior to or during the pendency of any trial for a violation of this section. So they went out of their way to say they're not going to arrest somebody, but they would file criminal charges. Now, Kansas, like California probably, they didn't follow through on this. This was 2013, and they did let two good people get arrested by the feds rather than following this law and actually going in there and filing charges. So Kansas actually, this was more of a grandstanding thing, and they let two good people's liberty get attacked by Washington, D.C. That's a whole story for another episode, and I know a number of our supporters have asked some follow-up questions about this or have followed this more closely than I have personally, but I do know that Kansas failed to follow through, even though there is a law on the books at the state level that says that it's against the law for feds to do this. This is also a very similar law. Oh, wait, first of all, I want to point out that for years, we have heard from a small segment on the right that anytime you try to do anything to defeat a federal program, even if you're using James Madison's advice from Federalist 46, where he said, refuse to cooperate with officers of the union, using noncompliance on a state or a local level, which is incredibly effective, we will always or often get complaints from one side of the right or one part of the right that says, look, if you don't have what's called teeth, if you don't have provisions in the law to arrest federal agents, the whole thing is worthless. You're wasting your time. Even though we can see that no states out of the 33 that have legalized cannabis for various purposes, in varying degrees, are getting away with it without arresting any federal agents. We can see that this type of non-compliance actually works. Legalizing what the federal government prohibits or not participating in federal enforcement is actually very effective. And James Madison told us that. I've got a bunch of episodes and articles. If you're really interested in learning more, just ask. Post a comment or email me at team@10thamendmentcenter.com. So we don't hear it as much these days because I think people are really learning that, like, look, when you try to do this whole teeth thing, it doesn't really play out like we want because states will pass something like this, like Kansas, and then people will believe that the state is going to protect them, and then the state doesn't because they're lying bastards. They're just politically posturing, and they don't protect those people, and then they get arrested. And then they lose their liberty, at least in some way. They're felons. But a similar law was actually signed in Wyoming in 2010. And in fact, as that bill HB 95 was actually being considered, and for a number of other pieces of legislation, I know there was a bill that we supported in Texas that would arrest federal agents for trying to implement Obamacare that we were supporting. It didn't pass. But HB 95 in Wyoming was signed into law. It says any official, agent, or employee of the U.S. government who enforces or attempts to enforce any act, order, law, statute, rule, or regulation of the United States, again, this is on a personal firearm, a firearm accessory, or ammunition that is manufactured within the state, stays within the state. So basically, they're trying to avoid Commerce Clause questions, although they don't really, I don't think they're really understanding how the federal government applies the Commerce Clause, which is basically all human interaction all the time, anything and everything. But anyway, so they're trying to reaffirm, I actually agree in principle that if something is in-state, this is not interstate commerce. It's pretty straightforward. But they say specifically, any federal agent who tries to enforce a federal regulation on this or a federal law shall be guilty of a felony, and upon conviction shall be subject to imprisonment for not more than 2 years and a fine of not more than $10,000. It may be, I have 10,000 and 2,000. I'm not sure if the final law actually had 10,000 or 2,000. So basically a fine, a felony conviction, and 2 years in prison for federal agents. No one has been arresting federal agents in Wyoming. So either you've got a bunch of really compliant people who live in Wyoming. I find that hard to believe. The feds just never enforce gun control there. I also find that hard to believe. Or this is just political posturing on the part of politicians knowing that, well, we'll kick the can down the road. We'll look good. We'll look tough. And it really won't happen in practice. So again, that's the whole issue there, to me, really, is that when you get down to it, it really never happens. I understand it in principle. And we've done a lot of articles. Mike Meharry has actually done a lot of reporting on this strategically, because we have to talk about strategy. If we really want to accomplish more liberty, what really works? And here's an article that we published back in 2014 from Mike, and he says this: the thought of a local sheriff or state police troopers swooping in and arresting federal agents as they violate the Constitution carries great emotional appeal. And as people can easily check whether someone has been arrested or not by visiting a few sites online, it makes it very hard even to deny the arrest or avoid talking about it for too long. So the notion is, it makes a lot of sense. Someone's violating the Constitution. They're violating someone's rights. They should go to prison. And I've covered quite a bit lately the idea of qualified immunity. This is this doctrine that was created in essence out of thin air by the federal courts, and then through the legal fiction that is the incorporation doctrine, they've taken that and applied it, supposedly under protecting us through applying the Bill of Rights to the states. That's supposed to protect us and having the federal government enforce that. But in practice, what that means is you create this doctrine that supposedly protects everybody, but what it really only does is it creates an environment where if you take some federal agent to court, they're going to throw it out. You can almost never sue a federal or a state or a local agent in court for violating your liberty, even to the point if they rob you, they rape you, they kill you, it almost never happens. And Mike points out that a lot of people think that you can't have real nullification without an arrest. Well, that might be a strategic way to get it done. And I'm not sure if we have any real historical... I'm going to go through some historical examples of how this has played out. But nullification, we just want the federal acts, the unconstitutional acts, to no longer exist. And if that means they no longer exist in practice, but they're still on the books, as long as people aren't getting thrown in prison. So we want reductions of enforcement, however that needs to happen. Anyways, he goes on. He says, but as much as we might like to see our friendly neighborhood ATF agent sitting in the back of a squad car with his hands wrenched behind his back, I'd actually prefer to see the ATF agents get real jobs because that agency shouldn't exist. We all know the joke. ATF should be a corner market, not a federal agency. So Mike says, as much as we'd like to see these friendly ATF agents sitting in the back of a squad car with his hands wrenched behind his back, or hers, including criminal penalties on federal agents and nullification bills, amounts to a legislative poison bill. And this is something we have made the case for a long time. Why? Mike goes on, he says, in a perfect world, every nullification effort, every nullification bill would include penalties on federal agents, and states would vigorously prosecute these oath breakers. But we don't live in a perfect world. And mind you, the states, I don't think anyone can name a state. I know everybody likes to think their place is the best and only California is bad. But every single state participates with the federal government, enables the federal government to enforce unconstitutional federal acts, whether that is asset forfeiture, and in some areas like California, it's far less than in others like Texas, for example. Prohibition on plants, it's less in California than it is in Texas or Kansas. Gun control, it's more in California than it is in Arizona and elsewhere. But they all participate, they help with this, they get lots of federal funding, and they reject, at least at the law enforcement level, any effort to restrict their participation in federal joint task forces because they love the cash and gear that they get from Washington, D.C. Now, here's the legal issue, and I said I would talk about how this plays out in practice under the status quo, and it's important for you guys to understand. This is going to be a little kind of a little geeky, but it's important to know what's going on and how this plays out. And Mike writes it this way. Under current federal law, any case involving a federal agent acting with the scope within the scope of his or her official duties gets removed to federal court. In other words, the structure of the legal system makes it impossible, absolutely impossible, to prosecute a federal agent in state court. This is 28 U.S. Code section 1442 A1. I'm not going to read the whole thing, but the short version, you can click into the link. I'll include the link in the show notes so you can actually read the text of this. You can Google that yourself. And it is in federal statute that anytime a federal agent is doing their job and most of their job shouldn't be done under the Constitution. If we're talking about ATF, DEA, basically most of the federal agencies out there, they should be doing a different job. They should go work for a department store. They should start their own business. They shouldn't be violating people's rights. Just having that job is a violation of someone's rights because the job shouldn't exist. The money that they steal from people shouldn't be stolen in the first place, but I can go on and on. So let's do an example. And Mike goes with Missouri because we have backed efforts to pass a Second Amendment Preservation Act in Missouri for many years. We were getting very close this year, and then suddenly the legislature had to stop because of a pandemic. But let's say Missouri passes a law, Mike writes, criminalizing the enforcement of federal gun laws within the borders of the state. Under the law, a county sheriff goes and arrests an ATF agent. Sounds great, right? Lawyers, though, for the federal agent would immediately, absolutely within minutes, make a motion to remove the case to a federal district court under 28 U.S.C. 1442A1, and the state judge would comply. That's the big issue there. The state judges will comply every single time. State judges are not your friends. I know in the past I've talked about how having removing qualified immunity on a state level at least gives you a chance to go to state court rather than relying on the feds. And at least there's a chance. With the federal system, there's no chance. But in this type of a situation, all the state judges believe that when a federal court tells them they have to do something, they all comply. Now, if someone can show me examples of how state courts will resist this, then that could change things a little bit. And maybe we need to focus on that a little bit in our activism and our long-term planning for liberty. So in that situation, the judge complies, and then the case leaves state hands. And then once in federal court, Mike writes, the game gets played by federal rules. Now, this is another important point here. He says, generally, federal agents acting within the scope of their duties, not within the scope of their oath, because their oath means they would quit. If they were following their oath, they would just go get a job. They enjoy, in most situations, they enjoy sovereign immunity. Now, sovereignty means final authority. The founders recognized in the pre-revolutionary days, 1764, Sugar Act time, 1765, moving forward, maybe even as early as 1763, that this was a problem. Like, the king in parliament, that's how they put it, the king in parliament could do no wrong. So if you're sovereign, and that's why the founders set up a system of popular sovereignty under the 9th and 10th Amendment and the Constitution itself that recognized that the people of the several states held final authority or sovereignty. So in general, federal agents enjoy sovereign immunity in court. As long as they can make the case that I was just doing my job, this is what I'm supposed to be doing. But precedent does allow for state prosecution of federal agents in some situations. It's very, very rare. To fall under immunity, a federal agent must do no more than is necessary and proper in the performance of his duty. That's a case, Clifton versus Cox, 1977. And he goes on. He says, if the agent can show that he reasonably believed that his actions were necessary to perform that job and had no other motive than to do his job, he will fall under immunity. And that is a very easy thing for a federal agent to tell a federal court. Very easy. Almost every single time they act like a rubber stamp. Mike puts it this way. In other words, the prosecution would have to prove there was criminal intent outside of enforcing the federal act. They aren't going to say someone is a criminal for forcing a statute that's been passed by Congress, let's say like the National Firearms Act of 1934. They aren't going to say that that is it. Or grabbing someone off the street in Portland. They're going to say, well, they're protecting federal buildings, even if they're nowhere near the federal building, and even if that person had nothing to do with damage to that federal building, or even if they're enforcing criminal laws that Congress has never been authorized to enforce. The federal courts will say, well, they were told by their superior, they're following their orders, and we've got it on the books that they were trying to do that job. It's going to be a very high bar to try to convince a federal judge that a federal agent should go to prison for following orders. Mike points out that, in fact, a federal agent once committed burglary, literally committed burglary, while participating in a sting operation. The judge let the agent go because he claimed he committed the crime as part of the undercover operation. In Utah a few years ago, I think it was 2017 or so, and TJ Martinell actually reported on this a few years ago. There was someone who was arrested for, I don't know if it was assaulting an Uber driver or something like that, but he clearly wasn't in the midst of his duty. He was in the area for that, but he was actually able to be charged in that situation. But as long as he's saying that he's enforcing it, doing some kind of enforcement action, and there's all kinds of other agents doing stuff, it's almost impossible. And so Mike puts it this way: while the idea of arresting federal agents might sound exciting and make activists feel like we're really doing something, it will not happen, not yet. And again, I'm going to get to the caveat of when it does and how it has in the past. A federal agent will never face criminal charges for enforcing a federal law in the current climate ever. And if they do, it's going to go to federal court and the feds are going to let them go. He says it cannot and will not work because not one state in the country, not one state court anywhere, will try and convict a federal agent. Not one. They will all cite the supremacy clause incorrectly and turn the case over to the feds when asked. And of course, the federal courts protect their own. Here's how TJ put it in that he did a report. This was 2014 where someone was arrested in Salt Lake. He's like, it's like getting into a fight with a kid and having his mom decide who's right. It's not correct, but this is how it plays out in practice. That's bad news. I know it's not something you probably want to hear, but this is what happens. We can do something about it. I don't know if there's enough courage. And there's also this other code on the books, 8 U.S.C. Section 111. Under that, federal prosecutors, here's on top of it, it makes it even worse. Federal prosecutors can charge any person, including local police, including a sheriff, following their oath to the Constitution or claiming they are, whatever. They can charge any person with interfering with a federal officer. So because of that, he says, it becomes highly unlikely that local law enforcement officers would risk their life and family to carry out the arrest. So even if you can get this passed into law, like we've seen happen in Kansas, the law enforcement doesn't actually do anything about it. In Wyoming, law enforcement doesn't do anything about it. In California, law enforcement doesn't do anything about it, and probably not going to happen in Philadelphia either. It just doesn't work like this. In some way, though, this idea of saying, well, do it anyways. We've had people tell us do it anyways. And I actually like the persistence and the backbone. Like, look, everything's against us, but sooner or later, someone's got to do something. In some ways, Mike writes, the strategy mirrors the thinking of some abolitionists during the fugitive slave era, 1850s, 1840s. You can go a little further back than that, but primarily 1840s and 1850s. They advocated for the arrest of federal marshals engaged in fugitive slave rendition on kidnapping charges. They conceded that the arrests would almost certainly not lead to a conviction. They knew that they weren't going to get convictions on federal agents. But they passed laws saying they were going to do it, and they tried in some instances anyway. They knew they wouldn't even get an attempt at prosecution almost ever. But they reasoned that even if quickly released, the repetitive arrest of federal marshals would gum up the works and create a hindrance to the capture and return of fugitives in and of itself. So there's a strategic caveat here. Even if the entire system is against you, if you have enough people with the courage to say, let's do this anyway, then what happens? What happens? In another article, Mike points out that precedent, this was my article, I guess. Sometimes it's hard. We have so many of the same messages. This is in 2017. This was a script from one of the video series that Mike and I worked on together, our Nullify series, the first season from 5-6 years ago. Precedent does exist for states arresting federal agents who break state law in the course of enforcing federal acts. It does exist very few times in history. We know of at least 3 cases, there are probably more, but we can verify and document 3 cases involving the arrest of federal marshals trying to round up fugitive slaves in northern states during the mid-1800s. Vermont in 1854, I believe, it could have been 1855. Vermont passed a law making fugitive slave rendition, capturing a runaway, locking them up, and trying to send them to the South to bondage and ownership. They said that was a kidnapping offense. And they said that federal agents were included. In Michigan, and also in 1855. So I think Vermont was 1854. Michigan's 1855 for sure. The Michigan Personal Freedom Act guaranteed any man or woman claimed as a fugitive slave all the benefits of the writ of habeas corpus and trial by jury, even though feds said you couldn't. And it made any attempt to send a freedman south into slavery a crime. It says, every seized person who shall wrongfully and maliciously seize or procure to be seized any free person entitled to freedom with intent to have such person held in slavery shall pay a fine of not less than $500 nor more than $1,000 and be imprisoned 5 years in state prison. And Mike writes, note that the penalties apply to any person, and that included federal marshals and federal slave commissioners. So we've got Vermont, we've got Michigan, we also have Massachusetts. The Act to Protect the Rights and Liberties of the People of the Commonwealth of Massachusetts. It provided criminal penalties for any person who removed a fugitive slave from the state without proving his or her servitude in a state court under the criteria set up by the Act. It was no easy task. They set a really high bar. Basically, they wanted to stop fugitive slave rendition. They wanted to stop slavery. And Mike writes, like the Michigan Act, the Massachusetts law did not exempt federal agents. In Ohio, they took a slightly different tack. In 1857, they passed an act to prevent kidnapping, just straight up, an act to prevent kidnapping. Forcibly or fraudulently carrying off a free black person or mulatto in the law would get you 3 to 8 years of hard labor. Anybody trying to take an escaped slave out of Ohio was subject to the same charges if they failed to go to the proper court and prove this so-called ownership, which of course can't be proved over any person, but they were kind of playing that political game. So 1857, an act to prevent kidnapping. What happened the following year? September of 1858. This is from a great article we published in 2015. On September 13, 1858, a federal marshal in Oberlin, Ohio, arrested a fugitive slave from Kentucky named John Price. The marshal and his deputies took refuge in a hotel. This is an anti-slavery hotspot. They know that they might get chased down. We know in Wisconsin, thousands of people would break someone out of jail. In Syracuse, similar things happened. So there was strong resistance physically as well. But they still would go in and capture these people. It's kidnapping. The abolitionists tried to negotiate for Price's release. When that failed, they stormed the motel and found him hidden in the attic. They ushered Price out of town and eventually brought him safely to freedom in Canada. The event became known as the Oberlin-Wellington Rescue. And in Mike's article, he makes an important point that under the Fugitive Slave Act of 1850, one of the probably 3 worst acts passed in American history, I would say very much so, well, we could say the Federal Reserve Act. The Federal Reserve Act, the Alien and Sedition Act of 1798, the Fugitive Slave Act of 1850, and probably the Patriot Act. I'm sure there's a few others, but these to me always come to mind. I should always ask. I never added the Federal Reserve Act when I talk about these, but that really needs to be up there as well. So under that Fugitive Slave Act, an aiding an accused runaway or even interfering with fugitive slave rendition was a federal crime. Those found guilty faced up to 6 months in jail and a $1,000 fine. Now, if you're watching on video, you can see we actually have a handbill that was actually printed about this situation. So people were arrested. And they passed this out of jail. The rescuers are coming tonight. It's cool to see this historic stuff sometime. But going back to the report, a federal grand jury indicted 37 participants. So 37 people were indicted in the rescue under the Federal Fugitive Slave Act. In response, mind you, they have this act to prevent kidnapping that was passed the previous year. So in response, Ohio authorities arrested the federal marshal and his deputies. So the feds are saying, well, we're going to arrest all these people for violating the Federal Fugitive Slave Act. And Ohio hadn't done it yet, but they were thinking strategically. And so in response, they arrested the federal marshal and his deputies. That led to tense negotiations between Ohio officials and the federal government. Unsurprisingly, the state eventually released the federal agents without trial or punishment. But the feds also released 35 of 37 rescuers indicted and arrested. I'm not sure the behind the scenes. It sounds like there was a negotiation that happened. It sounds like they made a deal and said, okay, you keep the worst two, whatever that may be. A jury did later find those two people guilty in federal court, but they received light sentences of just 20 and 60 days in jail. One of the guys who was arrested and actually convicted was a free black person named Charles Langston. And before his sentencing, Mike writes, the court allowed him to speak. He admitted he did it, and he swore he would do it again. And I think when we get down to this caveat, can states arrest federal agents? We have to understand that the entire legal system and the states themselves, mind you, the local law enforcement is oftentimes acting as federal agents. They don't want to arrest their buddies. They call them our federal partners all the time. So they're actually part of the problem. So to count on, this is like going to the Supreme Court in the hopes that the federal court will limit federal power, or begging federal politicians to limit their own power. It really isn't necessarily a smart strategy, but in essence, if you can find the right people with the right courage, that is the caveat. Even though the whole system is stacked against us, all these codes on the books, all these unconstitutional acts, all the court precedent, all the immunity, qualified, sovereign, and otherwise, even with all that stuff against us, well, there is the right moral thing to do. And that's what Charles Langston, that was his position. He specifically told the judge, yeah, I did it, and I would do it again. I just want to close out with this one piece. I know I've been going pretty long on this episode, but it's really interesting stuff. I hope you're enjoying this and learning something. He says, I shall submit to the penalty. At some point when dudes with guns are on you and you're in a court, you're probably in shackles, and you're black, and they probably don't like you all that much anyways. You helped someone escape to freedom in Canada. You got to kind of play it cool here. But this guy had some backbone anyway. I shall submit to the penalty, be it what it may. But I stand up here to say that if for doing what I did on that day at Wellington, I am to go to jail 6 months and pay a fine of $1,000 according to the fugitive slave law, and such is the protection the laws of this country afford me, I must take upon myself the responsibility of self-protection. And when I come to be claimed by some perjured wretch as his slaves, I shall never be taken into slavery. And he basically said, so help me God, I'm calling on you to protect me, you, the district attorney, the judge, all of you. This is our duty, to protect our life, our liberty from those who seek to take it from us. Well, I hope you guys, this is a mouthful today. I hope I'm making some sense here. I know I'm not really answering the question. I think, okay, I guess I'll try to answer the question. Can states arrest federal agents? Yes, they can. Will they? Almost never. What happens when you try to? Well, it doesn't play out too well. But philosophically, Charles Langston and the resistance to the Fugitive Slave Act in the northern states gives us a great example of heroism for liberty. Again, I hope you guys found this interesting. I hope it was fun to watch. I hope you learned something. I want to there's a lot of comments here. I'm on 45 minutes when I usually do a 30-minute show. Hi to Tim Curry over on Periscope. That's awesome. I just became a viewer, would love to get in touch about research. Feel free to email team@10thamendmentcenter.com, all spelled out, team@10thamendmentcenter.com. I don't get a chance to respond to everything, but I do read through all the emails and comments. Patricia Dance says, great episode. Thank you so much. Michael Dishman says, what does this have to do with what's going on today? Well, I think there are people who call for federal agents to be arrested, and I think all of this information should be explaining how does this play out in practice. Will this happen? Will the localities do it? I've got a number of examples that show, Michael, that even when they pass a law that specifically says the federal agent is going to get a criminal charge, they don't follow up on it. So it's generally all talk. That's an example. I've also explained how it plays out in court if they try to do it. And then I've also explained the caveat of my opposition to it strategically to show that, well, maybe you can do it if you have the courage and the backbone and the willingness to be consistent about it. And I haven't seen anyone do that. Hopefully that answers your question. Les Lay says, wow, when Michigan believed in freedom. Actually, a lot of Massachusetts, I mean, if you think back in the day, the revolutionaries, I mean, John Adams, when he was a good guy in the old days, prior to the revolution and up through the revolution, before he became president, John Adams, James Otis, John Hancock, Samuel Adams in Massachusetts. I mean, this is one of the most anti-freedom states in the country. So those are the days. Roddy Stegman says, this is wrong, but the courts defer to the agencies. I think that's over on Periscope. I love it when people check in on Twitter and Periscope. That's pretty cool. Thank you. Wrong as far as how it plays out. The courts always defer to the other federal courts. They just act as, I hate to use the word slaves, but man, that's awful. Also point out, Roddy, yes, I'm thinking the same way you are. They are protected by the agencies for which they work. Bob Brewer, good to see you, buddy, says, until we have the righteous mob to insist on unalienable rights. I wish you could see the testimony of Smith County commissioners in court yesterday. If you've got a link to that, Bob, please do email that over to us. Would like to check out what you're talking about. Our system isn't perfect, Justin says, but it works reasonably well. Well, maybe I'm missing out. I think it works pretty well for big government. I probably am missing the context. Bob Brewer says, how does asset forfeiture protect our unalienable right to property? It certainly doesn't. That's a good question. And that is an unalienable right. You can't have, and James Madison, I did an episode, Founders on Property Rights, and just to keep, this is, I know, a side note, but James Madison did a great essay on property. And when he talks about property rights, he's not only talking about physical property, owning land or owning stuff, he's talking about property in oneself, in one's thoughts, your ability, your right to keep and bear arms, to defend yourself is defending the property of your own body, to have thoughts and to speak. Free speech is property of mind. Madison was way ahead of his time. Anyways, I'm going to read through the rest of these comments a little bit later. I'll reply to at least some of them. I always get lots of ideas for future episodes. You can leave them in the archive in comments. You can also send feedback to team@10thamendmentcenter.com. Again, I hope you found this interesting and educational. It's a big one to digest, but I hope you learned something. That's the most important. If you support the show, please smash that like button, leave a review on a podcast platform like iTunes, share a link. All that stuff tells the platforms to show the program to more people. And of course, if you really want to get in on it, you can support us through our membership program for as little as $2 a month. There's a lot of you guys out there, and I'm very grateful for you putting your financial faith behind the 10th Amendment Center and the show. You can sign up for a membership as little as $2 a month, 10thamendmentcenter.com/members. Or if you want to donate just one time without joining anything, that's 10thamendmentcenter.com/donate. Please don't feel obligated, but if you're able to consider that, I'm very grateful for your support. Again, thank you so much for joining me today. Thank you for watching. Thank you for sharing, liking, and all that stuff. I appreciate you being here, and I hope to see you next time here on the path to liberty.